novel point of law in that case was whether the accused had the right of access to information and documents in the possession of the state and pertaining to the case, but not included in the case docket. In that case, my lord, the accused was facing charges of fraud as well as statutory counts which involve complex financial, legal, and commercial issues. And the paragraph that we want to put emphasis on is at page 451, it's paragraph D to E, where the court held that where such a document was in the possession of the state, and in here, my lord, the emphasis falls in the possession of the state. It ought to form part of the docket, and we argue, my lord, that Rowan's case is distinguishable from the current case in that the state is not in possession of the notes mentioned by the witness, not in Rowan's case. And we also mentioned that Rowan's case is distinguishable from the present case in that, as we've just intimated, my lord, in Rowan's case, the cases relate to fraud and involve complex financial and commercial issues. We also refer to the locus classicus of State versus Shabalala, 1995, volume 2, SSER 761, decision of the Constitutional Court, and the case of State versus Buota, 1994, volume 4, SSER 541, decision of the then Witwatersrand local division. And we qualify that, my lord, that in that, or in those cases, they only dealt with witness statements contained within the docket. Then under section D, we deal with what we perceive to be the legal position. In paragraph 9, we refer to section 35(3) of the Constitution, which states that every accused person has got the right to a fair trial, which includes, firstly, or in the context of the current case, the right to be informed of the charge with sufficient detail to answer it. And secondly, in the context of this case, the right to adduce and challenge evidence. In paragraph 11, we mentioned that the Constitutional Court in the case of Shabalala and others versus Attorney General Transvaal and another, 1996, volume 1, all South African law reports at page 64, the Constitutional Court held that the defense is entitled before the trial to all statements in the police docket, except where there is a reasonable risk that disclosure of a statement will lead to divulging of state secrets, method of police investigation, the identity of informers, or could otherwise harm the interests of justice. And further held that the court must weigh up the respective interest, that the defense must set out a prima facie entitlement to access, and the state must advance justified grounds for refusal. And we refer to the relevant paragraph, page 16, paragraph 16. As a starting point, the defense is only entitled to documents contained in Part A of the docket, and my lord, that they've been furnished with witness statements, expert reports, and documentary evidence, except defense is also entitled to copies of documents which are not in the docket, but which are in possession of the prosecutor or the state and which form part of the state case. As we've mentioned repeatedly, my lord, that the state is not in possession of the statement stroke notes. And in paragraph C, we state the test that ought to be applied in a request of this nature. And in paragraph, we state that the basic test in the present application must be whether the right to a fair trial in terms of section 35(3) of the Constitution includes the right to have access to notes that were used in the compilation of a statement. And similarly, and borrowing from the language used in Shabalala's case, it was held that this is not a question that can be answered in the abstract, but with regard to particular circumstances of the case, and in the broad context of a legal culture of accountability and transparency manifested by both the preamble to the Constitution and the Bill of Rights. This was per Justice Mohammed, the late Justice Mohammed, and refer to the relevant pages, page 26, paragraph 35 to 36, wherein he held as follows: ordinarily, an accused person should be entitled to have access at least to the statements of prosecution witnesses, but the prosecution may, in a particular case, be able to justify the denial of such access on the grounds that it is not justified for the purpose of a fair trial. We mentioned that what a fair trial may require in particular case depends on the circumstances of each case, as it was mentioned on page 26 of Shabalala. And in paragraph 14, the question in casu is whether the disclosure of this witness statement, I think the statement is missing there, is sufficient to enable the defense to prepare its own case sufficiently or to properly exercise its right to adduce and challenge evidence or to identify witness who might be able to contradict the assertion made by the state witness, or to obtain evidence which might sufficiently impact upon the credibility and motives of the state witness during cross-examination, or to focus properly on significant matters omitted by the state witness in their depositions, or to properly deal with the significant matters deposed to by such witness in one statement and not in another, or deposed to in a statement and not repeated in the evidence, or to hesitation, contradictions, and uncertainties manifest in a police statement, but overtaken by the confidence and dogmatism in viva voce evidence. This is a passage that we quote from Shabalala, page 27. From the Shabalala case, in that we are not dealing with the request for disclosure of a statement, but disclosure of notes, recordal of events which were used to draw up a statement. And we mention here, my lord, that the defense will usually not be entitled to memoranda in the docket, in the B part of the docket, and here we refer to motivated index of internal reports and memoranda contained in Part B of the case docket, and the investigation diary contained in Part C of the docket. And in the Shabalala case, the court set out the following guidelines in resolving the issue. Firstly, the court held that it is difficult to conceive of any circumstance in which the prosecution can justify withholding from the accused access to any statement or document in the police docket. And here, my lord, the emphasis falls in the police docket, which favors the accused or is exculpatory. And secondly, inherently, there might be some element of uncertainty as to whether the disclosure of the relevant documents might or might not lead to the identification of informers or to the intimidation of witnesses or impediment of the proper administration of justice. And in light of the fact that the state hasn't seen the notes or statements, we are not in a position to advise the court as to whether there's any prospect of intimidation of witnesses or impediment of the proper administration of justice. And the court then went on to hold that if in the special circumstances of a particular case, the court needs to exercise disputed documents in order to make a proper assessment of the legitimacy of the prosecution's claim, and any insight that document might reasonably defeat the protection which the prosecution is anxious to assert, then the court will be in touch of its contents, but making proper allowance for that factor in the ultimate decision. This, my lord, was the proposal that if the notes were found, that was a proposal that the state was going to make, that and then inform the parties as to whether there's any possibility of intimidation or impediment of the proper administration of justice. However, in light of the fact that it has since now become moot, what is important, my lord, in this regard is that the court is vested with a wide discretion as to what should a topic which the police as to those that apply to form part of the integral part of the witness statement. We mentioned that the state can refuse to disclose privileged information taken up in the diary, but the reasons therefore must be disclosed, and we refer to the case of Jonas versus Minister of Law and Order, 1993, Volume 2, SACR, page 692 is the decision of the Eastern Cape at 696 E to G. And we mentioned, my lord, that the police are issued with diaries or pocket books specifically for the purpose of documenting events which would assist them in compiling their statements at a later stage. And we mentioned here, my lord, we have seen, for instance, in the case of Warrant Officer Musia, that his pocket book forms part of the, or it is an integral part of his statement, and as he documented certain events therein, and the extract of his pocketbook has been handed up as Exhibit C4. And in Jonas' case, should be Jonas, not Johan's, Jonas' case, it was held that information recorded with the purpose of being used in the preparation for or in the prosecution of the trial and forming part of the prosecution's brief, for instance, contents of the pocketbook, form part of or form an integral part of the witness statement, and or they are trial and to form part. There should be part to form part of the prosecutor's brief. We submit in conclusion, my lord, that that the notes made by the witness stand on a different footing from a policeman's diary or pocket book, and should not be subject to disclosure, but subject to the corollary, my lord, that the court should first have a judicial pick of the notes and then inform the parties as to whether there's any possibility of intimidation or the impediment of the administration of justice. And we submit, my lord, that this witness, Constable Zungu, should be cross-examined on the basis of his statement and the explanation that he gives for any contradictions between his testimony and his statement will be subject to any credibility findings that the court will make at the end of the case. That, my lord, are our submissions.
Okay, thanks, Mr. Baloyi. Kamusipiri, Mr. Okay. Of all of you?
For me.
For you?
For me, my lord.
Okay, Mr. Ngumalo.
My daughter, I did not also prepare the heads of arguments. I was of the view that it was a matter that was going to be argued on Tuesday or Wednesday.
How? Tuesday, Wednesday?
Yes, that was the understanding.
I'm in court on Monday.
Yes.
Okay, Mr. Mshololo. Sorry, Ms. Mshololo.
My lord, I will address the court. I did not prepare the haze, but I'll argue. I'll make my submissions, my lord.
Now?
Yes, my lord.
Make them.
No, I mean after this, my lord, because Mnisi is going to take the space first, my lord.
Oh,
and
okay.
then
Mr. Mnisi, they say you should. Yeah,
In the same
Mnisi?
breath, with my colleague, I did not prepare something readable in line with what the state has done, and that is not out of contempt of the court. However, I understood the court to mean that if we can do so.
Yeah, fine.
But nonetheless, my lord, the issues here are very crisp and very succinct. The court will remember, just before I could commence with my cross-examination, I brought it to the attention of the court, my lord, that I had a conversation with the state wherein I actually requested the original copy of the statement because the copy that we were issued with is a typed version. Then the state said no, it did not have such a handwritten statement.
Right.
I thought that the matter would then have rested at that point. However, subsequent to Mr. Zungu's testimony and him being cross-examined by Mr. Ramusipili on behalf of accused number 1 and 2, he mentioned very unequivocally that there is a statement that he wrote with his own hand. He initialed it, he initialed each and every page, he signed it.
So Mr. Zungu says there is a statement.
Yes, my lord. I'm still addressing the court.
Yeah. It's not being interpreted. Do you understand what Mr. Mnisi is saying?
Yes, I do.
Fine. Okay.
Thank you, my lord. You said there is a statement that he himself wrote in his own hand. He initialed each and every page thereof. He signed it, and it was commissioned. And I then said it would really be very grateful if we were to be furnished with that original statement, my lord, that is handwritten. That is when then the whole issue started to be thrown into disarray. That's when the explanation regarding the existence of a note from which that statement that is typed was compiled from, that is how then the issue developed.
Okay.
Then accused number 3, gentleman that I'm representing, my lord, called me or drew my attention to the testified about by Mr. Zungu, that he says he initialed each and every page thereof, that he said he signed it, that he said it was commissioned. It's actually on record. It is actually on record.
Actually on record?
Yes. Then what happened, my lord, after the court had made an order that there should be some kind of an escapade to go to KwaZulu-Natal to go and look for those notes, which apparently today the explanation is given that they've been shredded, they cannot be found, then ensued. But we had an opportunity, myself and my colleagues, to go and have a listen to hear what the record, insofar as Mr. Zungu's testimony on this aspect of the inquiry is concerned, my lord. I may say, my lord, without any fear of self-contradiction, that what we've been maintaining all along is confirmed by what is stated in the record. And in fact, I would have requested this court, my lord, that just to put the matter at rest, the court should, I'm going to request, but it's not an instruction, I'm going to request the court to consider actually listening himself exactly what Mr. Zungu said about the statement, my lord.